All right. So this is recorded. It will be posted on our YouTube page in a couple days. You are free to watch it as many times as you want, or have folks that maybe couldn't make it with us today to view it. So again, I'm here on behalf of the Campaign to End Homelessness. We're so glad that you've come to hear about this information. The way it's going to work is we're going to have two folks present the content, and then we're going to have Q&A at the end, maybe some discussion. We would love it if you could ask your questions in the Q&A button. You can react in the chat if you would like, but we're hoping that all questions will go into the Q&A. We will try to get as many answered as we can as possible. And if we don't get all of them, I will do my best to answer them in a follow-up email. So with that, I am going to pass it off to Robert, who is our first speaker.
All right, great. Nice to see everybody. Allison, does everything look and sound all right?
Perfect.
All right, perfect. Well, thanks for joining us this Monday. My name's Robert Goodspeed. I'm a associate professor of urban and regional planning, and one of the individuals involved in this research. So our lineup today, I'll be speaking about the two research reports that we published. I'll tell you a little bit about what's in them, give you some highlights, and then following me is Jim Shasma, who will speak more to kind of the contemporary policy and programmatic conversations happening. And I suppose I'll just to conclude my introduction, although evictions is one area of research, I also do research and have expertise in other planning topics, especially projects involving mapping, software, and data tends to be my niche. So Jim, go ahead and provide your introduction.
Thanks, Rob. Good afternoon, everyone. I'm Jim Shaftsman. I'm the housing attorney at the Michigan Poverty Law Program. Pleased to be with you this afternoon and look forward to our time together.
All right, great. And as you'll learn, Jim's been, and his organization, been a collaborator on the work. I already mentioned there are two reports. So my collaborators and I were in an interesting situation at having completed a major policy report about evictions at the eve of the pandemic. So if you can cast your mind back to the early months of 2020, we had just finished this big report, and very quickly evictions became a major focus of policymakers' attention and attention by folks such as yourself. So we found that our work had a ready audience, but of course there's been so much that's happened in the past year or 2 years, and so therefore we reconvened a somewhat different group, and we prepared this follow-up report, which is really addressing all of the changes that have happened, presenting some new data, and providing updated recommendations. Before I forge farther, I realized I forgot to say something I wanted to say, which I wanted to thank Allison and the Campaign to End Homelessness for extending the invitation to have us come and speak with you. Really heard good things about the work this group is doing, and we're happy to be here.
Thank you. Thrilled to have you.
So the genesis of this first report was really the launch of Matthew Desmond's Eviction Lab website, which has, for the first time, national data about evictions in every different state around the country, or many states. And a collaborator, Elizabeth Benton, who at the time was a legal aid attorney, reached out to me knowing I was this data expert and sort of said, look, this data for Michigan seems, I've talked to my colleagues, we think it's really off. And so I began to dig into the methodology behind that data portal, and one thing led to another. We discovered that there were data available about evictions in Michigan that those researchers had not tapped, and we decided to apply to Poverty Solutions to implement a one-year project to culminate in a comprehensive report summarizing our findings. And so you can see the team here. So Jim did participate in this project, as well as Marky Dewar, my planning colleague and housing expert, as well as Elizabeth, an attorney. And so we requested from the State Court Administrative Office data about all eviction cases filed for the 2014-2018 time period, and we were able to map it and do some further analysis. And in a moment, I'll explain some of the highlights from this work. And our conclusion here is, although The process is certainly changed, and a lot has changed. The places that are affected by eviction and some of the patterns of the types of households that are most affected, I don't think have changed. We don't have, and so we'll present some highlights here, and then I'll explain some limited data and updates from the second report. First, perhaps as an introduction, we learn that, of course, the legal aid advocates and the homelessness advocates have known the relevance of eviction for many years. In fact, there's a well-known article that described it as a hidden housing problem. But there's this growing body of social science research, which is quantitatively and rigorously documenting why it should be viewed as a policy problem. And so, of course, there's the direct eviction effects of eviction, loss of a home, often of belongings, and the creation of eviction record, which can follow tenants around through this shadow system to credit, where you have tenant bureaus keeping records about you have a kind of a score that landlords can check. In addition, there's growing evidence of other reasons we should care about eviction. It hinders people's ability to keep jobs. It causes physical and mental negative health outcomes, and it impacts children, and for good reason. So I think historically it was viewed through a typical moralistic lens of personal responsibility, but we're realizing that the vulnerable members of these households who really should bear no ill effects of their parents' mistakes are, it's actually a big problem for them. So there's been a broader reframing of eviction as a policy problem. Furthermore, there's growing evidence that there's disproportionate effects, and these are some of the groups that we know disproportionately are affected by eviction, even controlling for income. There's not extensive research because it requires collecting the sociodemographics of folks in order to kind of do the analysis, and they're not present in court records. But we know that women and low-income women, women of color, families with children, and domestic violence survivors are all disproportionately affected. So if you have an equity lens on the work, that's even further motivation to care about this issue. One of the important things that people always ask about, there's all this interest in the topic, but getting data can be a challenge. And so to explain what we did in our first report was we obtained that state data through a formal request to the State Court Administrative Office that they make data available to researchers. And we also obtained different types of data from local courts in a few counties, but primarily in Washtenaw County. The local courts were able to provide some electronic records. We ultimately couldn't do a whole lot with those, and I'm happy to get into that. We also went into the courthouse and we took a random sample of cases and we flipped through case files, and we created data from the paper forms and pleadings in the case files. And that was ultimately how we could get the fullest picture of what was happening. Top line conclusion here is we found through our analysis, Michigan had a very high volume of landlord-tenant cases. And in fact, it's equivalent to 1 for every 7 rental housing units. And as far as we can tell, there's not a good statewide data, but there is data for other cities around the country. And although there are many important differences in landlord-tenant law in different states, Michigan has a very high number of cases compared to the other cities that we could find. There is always interest in land contracts because of their prevalence, especially in Detroit. We found on a statewide basis, it's a pretty small percentage, and that's because we think they're used, especially in markets where mortgage lending essentially doesn't exist or is very hard to come by, like Detroit. So while some of you may work in communities where land contracts are a big issue, and many of you work in places where most of the cases are landlord-tenant cases. And just a taste of what we have. So the report has county and city level statistics. So kind of, how good or bad is your eviction filing rate overall? And this is kind of per 100 rental housing units. And we also were able to map down to the census tract level, and we created this online map with the assistance of our funders, the Poverty Solutions. And there's a link here, and then I'll have a link at the end of my talk where you can find that. And you can see there's a handful of courts that don't contribute digital data to the state warehouse. One of them is in Grand Rapids, shown here. One is in part of Macomb County, I believe the Berrien County court system, so it's maybe half a dozen. But most courts' data are included in this repository. And so that's the high level. What do we learn from digging into the case record? So here are some findings. We learned that most cases were for only 1 month's worth of rent. And so the average was 1.5 months. That's because it's a skewed distribution. There's a small number of cases where it's like 4, 5, 6 months. Almost the most common value we found is like 1 month, maybe a little bit more. About 22% of the cases in Washtenaw County went all the way that were filed, went through to the court issuing an order of eviction. We've since learned in the following slides that that's roughly a quarter to a third is a statistic that holds statewide. And then the defendant here is the tenant. So very few tenants won their cases, got possession, but there are other dispositions. So the folks who didn't get an order of eviction, the cases may have been dismissed due to the landlord and tenant coming to an agreement or the tenant moving out. Another thing we found is that a lot of the landlords, so here at Washtenaw County, 97% of landlords are represented. It's pretty much universal. Only about 9.5% of the tenants were represented. In the statewide data, it's less than that. And so it's under 5% of tenants for that 4-year period had representation versus 83% of landlords. So we think this is an important conclusion when you have an adversarial process that requires tenant self-advocacy to understand their rights and understand the legal process. So we're painting a picture of what we found. We drove even further with the data that we had. We wanted to understand, we didn't have enough individual case data to look at things like equity at an individual level, but what we could do is look at what are the qualities of different tracts or neighborhoods that have higher or lower eviction filing rates. And without going into too much detail, we published an academic paper, which I'm happy to send to anybody on the left. And really what we found sadly confirms some of the findings in the literature that neighborhoods with single mother households and with a lot of children had higher eviction filing rates. And depending on the model, there did seem to be some evidence of a relationship with neighborhoods with higher African American populations had higher rates. And then some of the characteristics of housing. So places where there's mobile homes, mortgage foreclosures, multifamily structures, vacant structures, where had higher eviction filing rates. On the kind of plus side, like what's good to have, educational attainment. Actually, counterintuitively, the higher poverty areas had lower filing rates. So it could be that those areas are better served by legal services. It could be they have more subsidized affordable housing, or there's something else going on. Obviously, home ownership and a kind of a positive thing. We tried to explore other variables and about access to legal services, but it was really difficult to kind of quantify some of those things, so we didn't find relationships. And perhaps one final point about this paper is in the analysis in the paper, we explored differences between urban and rural areas. And for example, we found that in rural areas, it's a lot about mobile homes and mobile home parks with very strong relationships. And some of these other characteristics don't really apply as much. So if you are serving a rural area that may be of interest to you, I'd like to say that the research has shown that eviction does affect both urban and rural Michigan, but in different ways, so somewhat different households and in different types of housing units. And so we have some details that may be helpful. Okay, so this is all well and good, and you've enjoyed learning about what I did pre-pandemic, but you may be sitting there thinking, well, gee whiz, there's CERA, there's all these crazy new programs and funding. What about all that? And so we got the band back together, so to speak. Jim helped, but he's not an author on this one. He's still in the mix. And we wrote an update report that we published just in June. And we didn't get as much data, so it's a little bit less data heavy than the first report. It's really geared at providing concise, clear updates about these different policy areas, and then providing updated, very granular recommendations. And my conclusion is eviction it's a sticky problem, but it also means that there's no matter who you are, there's steps you can take. So we have recommendations aimed at the federal government, the state legislature, the governor, the state court administrative office, local officials, social service providers. So really kind of organizers. So there's something in here, hopefully for almost everyone. And we organized it in these different areas, and Jim will provide in a moment deeper dive background in some of the policy developments you might be aware of. I won't be doing the detailed policy, but I did want to show just a couple of the charts that we created. So the State Court Administrative Office has been releasing kind of aggregate data so that we have a sense of what's happening. And from that, we created this chart that shows, of course, in 2020, the main pandemic year, although we're still in it, the courts closed and or had total freezes. Then there was a kind of reopening process in late summer. And then since then, the case volumes have been somewhat subdued. And of course, over this time, there's been the federal stimulus payments and a whole slew of changes to court procedures and the creation of new assistance for tenants. So all of this sort of combined has resulted in this situation. And the various programs and moratoria starting to end, our thought is let's have a conversation about what should be done to prevent this chart from returning to the bad old days of the roaring 19s, if you will. A cool thing that the SCIO has also done is for a subset of courts where they have detailed data, which cover courts that handle about 2/3 of all of the landlord-tenant cases in the state. So I think there's a it's reasonable to conclude that the pattern shown in this chart is true for statewide. And so what it shows is the rate of cases filed that went all the way through to an order of eviction. As I mentioned earlier, we know in Washtenaw County it's a little bit lower here, but in overall in the state it's between 1/4 to around 1/3. That plummeted, and that's due to various factors, and then we can see that has begun creeping up. However, this chart ends in April, and the more recent data, which is available, shows that it's not continuing on this linear trajectory. It's sort of bouncing around at this lower level. And that's probably due to the persistence of the assistance and other changes that have been made. So although we've allocated 30 minutes, I was hoping to kind of end early to allow plenty of time for Jim and then for discussion. But to kind of wrap up my section, I having been involved in this, we've all taken turns on different media appearances. And so here's some questions we get. First of all, how is the coronavirus emergency relief or emergency rental assistance program running? There is a lot of talk about a data dashboard. At one time, there was a broken link on the website to a dashboard. That's been removed, and I've seen no data, and no one I've ever talked with has any data about that program. So anecdotally, we do have some data information about it. We know that rollout was a little slow. We think it's building steam. Maybe Jim has the latest gossip or anybody on the line. Number two, everyone wants eviction data. Your local court has it. They have some data in their electronic case management system. And I know that you can get it because I have got it from Monroe sent me data, and 3 of the 4, actually all 4 courts in Washtenaw County sent me data. But they may or may not know where the export button is. They may or may not be willing to do it. And if they do it, you may or may not be able to analyze it. I actually had to pay a grad student to write a program because it was in such a wonky format. If you're an academic, you can request it through SCIO, and all the rest of us can look at the reports that they've put up there, which is my source for the charts. Some of you might work in Detroit, and I'm aware of half a dozen or a dozen very legitimate stakeholders and researchers who have sought to get data from the 36th District Court, and no one has been able to get it out of them. But their data is in the statewide data. So that's why we do have track level maps from that. Okay, so that's maybe the few of you who care about data. You've heard plenty. Maybe the rest of you are kind of like, who cares about data? I'm sold. This is a problem. And then like, Rob, what should I be doing? You have this giant report with like all these idealistic ideas. And as a non-legal aid attorney, but with a lot of recent experience in research, I just pulled out a few. We think the legal representation is conversations about right to counsel, making permanent expansions in legal aid has received some funding through the various COVID response bills that has been helpful. Expanding the eviction diversion programs or institutionalizing them in different courts. There's a precedent pre-pandemic that we wrote about, we think can be helpful. There's other things the legislature could do about beefing up tenants' rights or increasing filing fees or preventing landlords from being able to tack on costs onto the tenant cases. And finally, in the court system, my legal aid colleagues have educated me about various things they think have been constructive, which have increased the access to justice and prevented tenants from having to take a day off work and drag their kids to the courtroom, including Zoom hearings, having a specific time instead of a cattle call, other administrative changes so that have the judge actually give them a pretrial hearing at the first hearing instead of making it a real hearing where if you're not organized, you could just lose by default or lose immediately if you can't formulate the right claims or produce the right evidence. And then finally, the practice we think has been very encouraging, having legal aid attorneys and other HARA staff like kind of in the virtual courtroom. But I realize I'm a little getting out of my depth on all these ideas, but this is squarely in Jim's court, and therefore it's a nice way to turn over to him. I'm going to I'm sorry. I'll go ahead and share. So I kind of personally compiled all these different resources, links to the reports and the other materials I've mentioned. And I'll share this link in the chat here. And then here's my email. I'm happy to answer questions today or follow up if there are any. Perhaps, are there any quick questions before I turn it over to Jim about anything I mentioned?
Doesn't look like any quick questions.
Okay. All right. Well,
I could be wrong, but they don't seem to be to me. So
all right.
We'll just hold them till the end.
Great.
Okay, folks, just give me a sec. I'm going to pull up Jim's PowerPoint.
And while Allison is doing that, I can first of all say thanks to her and the coalition for the opportunity to participate in today's event. And thanks also to Rob for the really good work that he's been doing on this enormous issue of evictions, and for your solid presentation today, offering an overview of the data, and also, as I am confident most of you know, of the really detrimental and lasting effects of evictions on families and communities. And I think we'll delve into some of those dimensions of the issue. As I said earlier, I'm the housing attorney at the Michigan Poverty Law Program, which is based in Ypsilanti. The Poverty Law Program seeks to support the work of advocates for Michigan's low-income residents. And so that's primarily legal advocates, most notably legal aid attorneys, pro bono attorneys, but not at all exclusively. We do a lot of work with organizations across the state and with government officials, elected and civil servants, both locally and at the state level. We do training activity for general audiences like today, and for more specifically legal audiences, some publication work. And then we do advocacy on our own, some judicial advocacy, administrative advocacy. So I work a lot with MISHDA, usually collaboratively, sometimes adversarially, and then also with the state legislature. So just a little insight into the organization I work for. And so building on what Rob has talked about, if you could move to the next slide, please, Allison, or thank you. So as I think many of you know, and let me just take one small step backwards to say that I have aimed to make my comments accessible to a general audience. So for some of you, this information might be a bit elementary, but I'll hope to add something to your knowledge of these issues and maybe give you a little deeper understanding of it. But, it's hard to do, but I apologize if for some of you, what I'm going to be talking about is too basic. So, as I tried, and maybe with not the best visual aid, but with a tripod, try to illustrate, what really Michigan's response to this eviction risk that is heightened a bit during the pandemic has been. And it's been for over a year now, a three-legged or three-pronged response. And that's consisted of moratoria, emergency rental assistance, and then an administrative order of the Michigan Supreme Court. And we'll talk about each of those in some detail. And on the moratoria front, we had a state moratorium dating back to March of last year, and that lasted for about 4 months. And there was a federal moratorium that covered federally related tenancies, so like public housing, but also properties that had federally related mortgages, and that lasted for about 4 months too. And then, there was the longest lasting moratorium, which was the CDC order halting many evictions. So that order wasn't comprehensive, and it required some tenant initiative in order for a tenant to get the protection of that order. But it was very helpful, on its own, and more so because it worked interdependently and it was complementary to these other interventions, emergency rental assistance and the Supreme Court order. But as I think many of you know, last month, the U.S. Supreme Court declared that the CDC didn't have the statutory authority to issue that eviction order, that eviction moratorium order. So currently we have no moratorium that protects tenants. And that has really knocked out one of those three legs or prongs to the protections that tenants have. And so that has really caused some difficulty and stress and anxiety for tenants and their advocates. And we'll delve into how that's presenting itself in a bit more detail. And so another of these primary interventions that you're probably familiar with is emergency rental assistance. And in Michigan, that's happened in 2 installments. So the first installment happened last year. So the second half of last year, we had what was known as the EDP. So EDP stands for Eviction Diversion Program, Rental Assistance Program. So that combined rental assistance plus legal assistance. And then the 2021 version of rental assistance is the SERA program that MISTA administers, and it's funded with federal dollars, and it's come in a couple of installments, and we'll talk about that in a bit more detail. And then another really helpful source of protection against eviction for tenants has been this administrative order of the Michigan Supreme Court that governs eviction cases in court. So if we could move to the next slide, please. And so we will talk about, I've talked about the moratorium that no longer exists. And I'll talk about some manifestations of it no longer being there. But first, we'll spend a couple of minutes talking about the SERA program, which I hope all of you have heard about. If not, it is the statewide emergency rental assistance program in Michigan. And I think somewhat troublingly that there still are a lot of people, most importantly, landlords, and more importantly, tenants who don't know about this program. So, there's been marketing of it, but in some respects, it probably hasn't happened intensively enough at the ground or the grassroots level. But so as I mentioned, that this funding is coming from the federal government, and it's come in a couple of pots. So the first is this, roughly $660 million that came to the state, and that was through the COVID relief, the federal COVID relief legislation that was enacted late last year. And so that is the money that is funding our current CERA program. And unfortunately, Rob mentioned this, the slow rollout of the program, and it was significantly due to it taking several months until nearly the middle of March for our state legislature to appropriate this money. And so it was just sitting in the state treasury for several months. And now there's this second installment of emergency rental assistance. It's commonly known at the federal level as ERA-1 and ERA-2. And this second installment comes from the more recent COVID relief legislation known as ARPA, the American Rescue Program Act. And so, again, that money is sitting in the state treasury, but it has not been appropriated for use. So fortunately, there's enough money with $660 million that our state legislature has appropriated. And so really not even half of that money has been used, which is both a problem and I guess a benefit because there's a lot of money still remaining. And as you probably know, MSHDA administers this program at the state level, and then locally it is administered by organizations called HARAs, Housing Assessment and Resource Agencies, which is a term that's used in connection with the HUD Continuum of Care program, which oversees the distribution locally of resources for homeless persons. And so, as was the case with last year's emergency diversion program, rental assistance program, the CERA program consists of rental assistance plus legal assistance, but also utility assistance and assistance for other expenses. And those other expenses take several different forms. It can be for supportive services, but also additional tenant expenses like a security deposit for a new place or application fees for a new place. And so, to be eligible for CERA assistance, the applicant family must have income under 80% of the area median income. And a priority is for families in the next lowest income category, 50% of area median income. And so just roughly speaking, for a family of four, if we're looking at Detroit, that is the 50% is $40,000. In Flint, it's a little under $33,000. Grand Rapids, $40,000. Lansing, right around $40,000 too. So just to give you some insight into where those income limits fall. And so families who are in that lower income category are also eligible for more months of assistance. And so it can be up to, and as you see later on in the slide, up to 15 months of rental assistance. And so there's these other criteria that a family had to have experienced some COVID-19 related financial hardship. It shouldn't be, and really almost everyone has done that. So it was a little problematic that eligibility criteria early on, but I don't think it is any longer, and it should not be. And the family would have to, we're not quite on to the next slide. So thank you. We'll get there. Maybe I'm moving too slowly.
Nope, I just hit my keyboard. So sorry.
That's okay, Allison. I'm just kidding. Maybe I need to accelerate my presentation. But and so, yes, in some demonstration of risk of homelessness, and really all that means is that the family has to show that they have some rent arrearage. The case, they don't have to even have received a demand for possession, which is the first step in the eviction process when a landlord serves a tenant a notice that the landlord alleges that the tenant is behind on rent payment. And then there are later steps in the eviction process consisting of the filing of a complaint. And just really quickly, there are 5 steps in the eviction process. So they are notice, they are the filing of a court complaint, they are the entry of judgment against the third is a hearing, and The fourth is the entry of judgment, and the fifth is the final step. So the issuance of an eviction order and enforcement of that eviction order, which is what happens when an eviction actually occurs. So when a family is dispossessed of their housing. So what has been really helpful, and I think I haven't mentioned it, I've said that the federal government has provided the funding for this program, but it's also provided a lot of direction. So this program nationwide, the ERA programs are under the auspices of the U.S. Treasury Department. So I think it's been really helpful in trying to make this rental assistance as accessible and easily usable as possible. So it's taken a number of steps to do that. And to its credit, that MSHDA has used most of this authority and most of these mechanisms that the federal government has said that state and local operators, administrators of these programs can use. And one of them is self-attestation of eligibility factors. So, if a tenant doesn't easily or can't easily produce documentation of these eligibility factors mentioned above, then they must be permitted to attest that they are eligible for them. And MSHDA, for the most part, as I said, has gone along with it. I mentioned earlier that up to 15 months of rental arrears can be provided. So that's for rent that came due after the onset of the pandemic. So beginning last March. And it can be also used for future rent in 3-month installments. And as I mentioned, it can be used for relocation as well. So a family doesn't need to have a current rental arrears, but can use or get CERA for relocation purposes, which we know is a real challenge. And any of you who are working with low-income families trying to find housing across the state know what a tremendous challenge locating new housing is, that the supply, and we'll talk about that when we talk about other possible policy prescriptions, but the supply of decent and affordable or even near affordable housing for people seeking rental housing in Michigan is extremely low. And it's probably, as most of you may know, so the standard measure of housing affordability is housing that consumes 30% or less of a household's monthly income, and that includes utilities too. And we're going to talk a little bit more about affordable housing issues in a bit. And so MSHDA has primarily used an online portal for applications for the program, but that in any area that a tenant must be able to apply in writing to. So if there are any impediments, whether it be because of disability or otherwise, for a tenant using the online portal, they must be permitted to make application in writing. So, as Rob said, and then there's also then here a link to the U.S. Treasury guidance if you want to delve into. There's a really helpful set of FAQs that is, I'd say, probably the primary guidance for state and local administrators of the program nationwide. So as Rob mentioned, the CERA program has kind of seen or gone in fits and starts. It was because of the slowness of the legislature in appropriating money. It got off to a slow start, and there have been, an assortment of issues that have slowed it down, that the money is flowing more consistently now, that there is some data, and it's primarily in the form, some that MSHDA has generated. Well, MSHDA has generated all of it, and some of it which it is required to provide to the Treasury Department. So you can see some of this data at this Treasury website. But you can see that the money has been increasing, and by the money, I mean the money that has been distributed for the benefit of tenants and landlords. And that's something I haven't mentioned, is that, yes, this program tremendously benefits tenants, but it also benefits landlords. So this is who the money primarily goes to, is landlords. And so it can be a great resource and benefit for landlords, for many of whom there's been some financial challenges during the pandemic. Know that still the rate of tenant rent payment has been above 80%, and it dips a little in the lower income categories, but it's still been significant. But this program offers a great help to landlords as well. So as I was starting to say, the money distributed has gone up each month, but that upward trajectory has been a little lower than hoped for. So the trajectory is good. We've been waiting for a long time for MISTA to have a dashboard. So that's something that most state and localities around the country have been using. And I think there are numerous benefits to it. It's kind of an accountability mechanism to show people, how this money is being spent. It shows how the experience is going in local areas, and I'll touch on that a bit. And it also offers some insight into where this money is being spent and who it's benefiting. And that goes to the equity issue that Rob mentioned. We know that evictions disproportionately affect certain categories of persons, and most extremely or most acutely female headed households and Black and brown households. So a dashboard would offer some insight into how equitably these CERA dollars are being distributed. So we've tried to, MISTA's been a good partner, I and others, so from the State Court Administrative Office and other agencies have worked closely with it in developing and trying to implement the program, that it's been very open to our input. And one major piece of our input was to build in equity. And so there are features to do that. We can talk about that a bit more. But a dashboard, and we've been told for the last several months, it should be next week. And most recently, we've told it's going to be sometime this week. So really hope that there'll be a dashboard, which would be a great source of better understanding of how the program is doing. I could talk about it if anyone wants to hear about it's more of the in the weeds details of the program. One thing I'd mention is there's a requirement, not a requirement, but the legislation that created the ERA1 funding said that a grantee like MISTA of the money has to spend 65% of its allotment, so of these $660 million, so a little more than $400 million here, in order to not be at risk of recapture of some of that money. So there's a slight risk. It's going to be close in Michigan, but I think even if it doesn't quite get there, if it's within range, that money won't be subject to recapture. But the aim is to spend that money. It is there, and there's more money, that money that hasn't been appropriated yet. So this money should be around. The expectation is probably through the end of 2023. So this isn't a permanent rental assistance program, but it is a long-term rental assistance program. And the amount of assistance available far exceeds what has ever been available to tenants and landlords. Just one other note that I'd offer about the program in terms of how it's worked around the state, that it's been going better in some localities than others. And there are a number of factors that can be attributed to. A major one is just the volume of demand. So a few of the most, what I could say, challenged areas have been Wayne County, especially the city of Detroit. And there's kind of an additional wrinkle for assistance in Detroit that pertains to the condition of the housing. So if there are serious repair problems, there's a holdback of 20% of the funding, and a landlord must certify that repairs have been made in order to qualify for the release of that money. And that's a good policy in one respect, but it hasn't contributed to the more rapid spending of those dollars. A few other places that have struggled a bit but are improving, Genesee County, Washtenaw County. So what in a few cases MISTA has done is started to farm out some of the cases from those localities to other places that have been much more efficient in working through and processing CERA applications. But we can talk more about CERA. Maybe I'll just get through this overview first. And if we could move to the next slide, please. Thank you. To talk about the Michigan Supreme Court Administrative Order, which has been really helpful. So this order was first issued in June of last year, and it has remained in effect since then. And this is just a summary of its features. What it requires in landlord-tenant cases now is a pretrial hearing, which hasn't always been the case in all courts. It has been in some courts, but not in all courts, and that's been really beneficial, so that if a tenant, for whatever reason, doesn't show up at a first hearing, and most hearings in most courts have been being done remotely, and that's starting to change a little bit, that if a tenant doesn't show up for that first hearing, that doesn't mean that a judgment by what's called default is entered, so that a landlord would get a judgment, which then would move the eviction process alone. So that's been really helpful. This order also requires courts to provide some additional information about assistance and other resources available to tenants. And then very significantly, there is now a provision in it that says that if a tenant has applied for CERA, so for the emergency rental assistance, upon reporting that to the court must enter a stay or what could be called a pause in the court case to allow the processing of that CERA stay. And that stay can be up to 45 days and even longer if the delay is attributable to the landlord. And the state court administrative office has interpreted that to include landlords who don't apply for CERA. So there's two ways that a tenant can get CERA. The one is if the landlord and the tenant both apply, in which case the CERA money goes to the landlord. But if a landlord is unwilling to participate in the program, a tenant can still be assisted, and the money is paid directly to a tenant who could use that money to pay a rent arrears or possibly to pay a new landlord for housing. And this CERA stay is available also in cases where a judgment has already been entered against a tenant. So as I mentioned earlier, that's the second to the last step in the eviction process. And so that stay can be available up to the point where a landlord applies for an eviction order, which is generally speaking 10 days after a judgment is entered against a tenant in an eviction case. So that window is pretty tight. Excuse me, but there is still a window for a tenant to get that CERA stay even after a judgment has been entered. Another really helpful feature of this order that it has suspended a local rule that exists in some places that required a tenant to file a written answer before even getting a hearing. And Rob, one of his slides mentioned this, and the research shows, the data shows, that in those courts where there was this local rule, that there was a higher rate of default judgments entered against tenants. So those judgments being entered where a tenant does not participate in the court process. And so and I touched on this earlier, but probably the biggest impact of the expiration of the CDC order is that this Supreme Court, the Michigan Supreme Court Administrative Order, recognized that CDC order and said that in cases where a tenant was under the protection of the CDC order, that a landlord could take a case all the way to the judgment stage, but no further in the case. So now the CDC order is gone. And so landlords can move to the next step in the eviction process, which is applying for an eviction order. And that's what we're going to start to see now, because there was one last payment period after the expiration of the CDC order last year for tenants to pay off any judgment, so non-payment of rent judgments, which determines or states the amount that the tenant must pay to the landlord in order to retain possession of the rental unit. So the CDC order is no longer in effect. So this part of the Michigan Supreme Court's administrative order is no longer in effect. And in these cases, now, as I said, just to underscore the point that landlords can apply for eviction orders. And I think that's where we're going to see an increase in the number of evictions in Michigan. So it's going to be very interesting, and I think troubling and a bit scary to look at the Supreme Court, the SCO, the State Court Administrative Office's data, and it's become a little more challenging because the Michigan courts just launched a new website, and some of the data is a little scrambled. So I hope we can get that sorted out in order to be able to track this data. And the other area where I fear we're going to be seeing more evictions or potentially more evictions is that I think, and this is kind of my speculation, so it's informed speculation, but it's not really strongly data-based, is that we're going also to see an increase in new court case filings by landlords. So I think that there are a fair number of landlords who are wary of the CDC order and sort of getting tangled up in it and decided, well, I might just hold off on filing an eviction case until the CDC order is gone. The CDC order is gone, so my theory will soon be tested about whether there'll be an increase in new eviction case filings. And again, I fear that there will be, but time will tell. If we could move to the next slide, please. So just by way of context, so that is my attempt, what I've just been speaking about for however long, is my attempt to kind of encapsulate what the pandemic-related policy responses to the eviction threat have been. And as the data show, and as Rob talked about, there has been a significant decrease in eviction filings and actual evictions. So that's good news. They haven't stopped. I mean, and I think there's some misunderstanding there that is a myth that evictions haven't been happening. They definitely have been happening, fortunately at a significantly lower rate than they were happening, but still at a very significant and troubling rate. And so just want to have people spend a lot of time looking at this slide. You can get this. So this is a one-page snapshot of Michigan's housing situation for low-income people, and it's from the National Low-Income Housing Coalition, which is a partner of the coalition. If you don't know about the National Coalition, it's a great organization. There's a lot of really useful data and information on its site, and it's been a tremendous advocate for renters and their communities during the pandemic in terms of pushing the federal government, of the administration, and of the Treasury Department to make the rental assistance program and other programs work for the benefits of renters and their landlords and their communities. So this snapshot offers some insight into the degree and the enormity of the affordable housing challenges and crisis in Michigan. That there is this huge undersupply of affordable and even near affordable, sometimes called attainable housing in Michigan. And so I present this for your knowledge, but also to make clear, and Rob touched on it a bit, that our shortage of this huge scarcity of affordable housing is deeply at the root of our eviction problem in Michigan, that there's a huge connect here, a very strong connect between this lack of affordable or near affordable housing and the eviction threat that faces low-income families. So Rob has touched on some of this. If we could move to the next slide, please. And so the question is, what can we do to try to guard against this eviction threat in Michigan? And so it kind of follows from what I just said. Well, we need a higher supply of affordable housing. To her credit, Governor Granholm has proposed that $100 million in money that Michigan has gotten from this law I mentioned, the ARPA, the American Recovery Program, be allocated to affordable housing development. So she's proposed this to the legislature, and this comes from another pot of ARPA money, what's known as state recovery funds. So really hope that the legislature recognizes the need for this appropriation of money for this purpose, because I think it's an embarrassment to Michigan and a bit scandalous that as it stands now, our state dedicates no general fund money, so none of the state budget to affordable housing development. So that doesn't reflect well on Michigan, in my estimation, especially considering the enormity of the problem. And also the infrastructure bill that's being debated up to, or more than $3 trillion bill would provide about more than 10% of its money for housing purposes, including a substantial amount for development of new affordable housing. So it'd be great, for housing purposes if that money, if that bill passes, including money for housing purposes. So Rob touched on some of these potential reforms in the eviction process itself. So what we suggest, what the report suggests, is that there need to be longer notice. So as it stands now, so for example, for a non-payment of rent case, as probably many of you know, that a tenant is only entitled to 7 days notice of alleged non-payment of rent before a landlord can file an eviction complaint in court. That period needs to be longer, as does what is now the 10-day period that a tenant has to pay off a judgment if the court determines that a landlord is owed money. That 10-day period also needs to be longer, to advance what should be the societal goal of managing, reducing evictions and the enormous societal costs of evictions. Also lowering cost and fees in cases. So there's a way that landlords in cases can get $75 to $150 kind of in bonus money in eviction cases, and that part of the law should be scrapped, as well as some other fees. So for example, late fees, not that landlords shouldn't be entitled to any late fees, but many late fees are exorbitant and go far beyond the purpose of late fees, which is to compensate landlords for the costs they incur because of late payment of rent. And if you look at those fees, so if we're talking about a $75 fee or a $100 fee, that those far exceed the cost, especially with interest rates as low as they are, of the costs landlords incur because of late payment of rent. Rob mentioned eviction diversion programs that the evidence in Michigan and beyond, shows that when a tenant has legal assistance in the case, that the outcomes are much better for them in eviction court cases. And the goal here should be what's known as right to counsel, that every tenant in an eviction case has a right to be represented. So that's going to be a real challenge, but we're kind of on that pathway now with the legal assistance component of the emergency rental assistance program. So the hope is that we can continue on that path. Getting a little further along, there's this prospect of a good cause protection against eviction. So for most of the federal rental assistance programs, the permanent programs like public housing and project-based Section 8 programs and the low-income housing tax credit program, tenants already have this protection, which means that it's not enough that a landlord simply wants to terminate a tenancy, but the landlord would have to have a good reason for doing so, such as a serious violation of the terms of the lease by a tenant. So that's a long way from happening in the Michigan legislature, just primarily because of the makeup of the legislature, and the landlord lobby is very strong in Michigan. But that would be a good, if not necessary, protection for tenants, because in my estimation, and I'm a tenant advocate, but the conversation needs to be reframed. And now, what we have is an eviction machine, and some of these interventions that we've talked about, rental assistance and the Michigan Supreme Court's administrative order, have managed that machine and slowed it down a bit, but still the machine really does favor evictions happening. So that picture needs to be reframed in my estimation. And as I said earlier, that I think to avoid the hugely negative consequences for families and for communities of eviction, that there needs to be some rethinking about how evictions happen. Also, just I think these will be my last points. That we need to look at ways to enhance housing opportunities, especially for low-income families. And here's a couple of ways to go about doing that, of making some adjustments to the rental admission and application process. So one problem in Michigan and across the country is that landlords, in looking at tenant applications for rental housing, consult or subscribe to tenant reporting agencies. And among the data that these reporting agencies and credit reporting agencies provide to landlords is whether or not a tenant has had an eviction case filed against them. And so there's a much higher likelihood, if the answer to that question is yes, that a tenant's application will be rejected. And a big problem with that process is it doesn't matter whether a judgment has even been entered against a tenant in a case. The mere fact that a tenant has had an eviction case filed against her or him means that there's that, to use credit reporting language, that there's that derogatory item on their report. And so, as a starting point, what the law should prohibit is landlords having access to eviction records where there has not been a judgment entered against the tenant, where there's been no finding that the tenant didn't pay the rent or committed a serious lease violation. So, and going beyond that is what many advocates are looking to do, and other areas as well, that there is legislation. And it's made some progress in some localities. For example, City of Ann Arbor, of what is called fair chance legislation or ordinances, that people with a criminal history, that they should not be immediately denied admission to housing because of that criminal history. That should be the last thing looked at, if at all. And then other protections for tenants. Some of you may have heard, and the coalition is part of a coalition that would create what's known as source of income protection in Michigan. So it would prohibit discrimination based on source of income. And the most notable form of that income is a Section 8 voucher. So landlords in many places, so there are many cities do have these source of income protections for tenants, but in many other places around the state, a landlord can say to a tenant who has a voucher, well, we can't count the value of your voucher. And because we don't do that, you don't have enough money to meet our minimum income requirements. So a source of income prohibition would protect tenants in those situations. And I think that it has to be that those protections have to be wed with what are called housing mobility programs, which enhance the prospects for tenants using those vouchers in what are sometimes called high opportunity or resource rich areas. So areas that are low poverty, that tenants with vouchers and other households should have opportunities to live where they want to live. And for many of them, it may be in their current communities where they have a lot of connections and support. But for others, it could be pursuing the chance to live in these so-called high opportunities, low poverty areas. And what the data shows is, not surprisingly, that kids who grow up in those areas have better educational and employment and health outcomes going farther. And that also applies to where new affordable housing is located. And too much housing, low-income housing in Michigan is located in high poverty areas. We need more, and there's a lot of challenges to locating affordable housing in low poverty areas, but we need to do that to provide better opportunities for low-income families, as well to counteract the horrible history of segregation by race and income that exists in Michigan. So there are a lot of other, and we can maybe talk about some of them. I've probably taken up too much time and cut into the question and answer period, but we can talk about these possible policy responses and others, but I'll leave it at that for now.
Thank you, both Jim and Robert. I will just read from the Q&A if that works for you.
Sure, and you'll see Jim probably hasn't looked at all of them, but I was responding to some of them during the talk.
Awesome. So the first question we got early on in the webinar is, hi, I've been referring cases of possible fraud over to MPLP. This seems to be cases of landlords accepting SARA funding, signing the paperwork, collecting back rent, and initially agreeing to take 3 months of future rent, and then upon doing so, immediately taking tenants to court to evict them. Have other agencies been seeing this? What recourse is there? So I'm not sure if someone from another agency has something they can add. You can raise your hand and I can unmute you for the part of, have other agencies been seeing this?
Maybe while we're waiting to hear the answer, it looks like Anna has raised her hand, which I'm guessing means that maybe she has, that this has been a long-standing issue of concern. And so in trying to develop the SARA program, that it was an issue that that housing advocates strenuously favored and pushed for. And there's kind of this narrow path of trying to balance interests, of not trying to create too many obstacles or impediments for landlords wanting to participate in the program, but also building into the program protections for tenants. And we tried to build those protections. There was tremendous resistance, not surprisingly, from landlords and landlords' attorneys to those. So, as it stands, that there are limited protections, but a landlord cannot, if they follow, and they're required to certify this. So it's basically they're creating a contract that should be enforceable by the tenant, to agree that they wouldn't start any kind of eviction proceedings until at least 1 month, after they've received the SARA payment. So that's a limited protection, but some protection, which in so termination of tenancy cases where a landlord is trying to end a month-to-month tenancy, for example, the landlord would have to wait at least 2 months. So 1 month according to the program, and then 1 month because they have to provide a tenant with a 1 month notice under existing law, before they can file an eviction complaint against a tenant. But yeah, it's been a really knotty issue and around the state, and a lot of landlords, I shouldn't say a lot, but multiple reports of landlords who are either defying the certifications they made in exchange for getting SARA, or looking for other ways around that. So I haven't seen too many reports from people directly. I get most of my information from legal aid advocates around the state, but it is in some instances an issue we've presented to MISTA. And again, there's not really solid data out there on this question, so I hope it's not as widespread as some, including me, fear. But it is a problematic. It's a programmatic vulnerability.
All right, thank you. We only had one hand raise up, so it doesn't look like it's happening a ton, at least in this webinar. So the next question we have is, what if the agency handling the SARA dollars are so far behind that it exceeds the 45 days?
Yeah, so that can be an issue. In the first inquiry there, or maybe not the first, but one of the things to look into, I said, if the landlord isn't participating, that should be reason to extend that time. Well, it shouldn't be reason, but that is reason then to extend that stay period beyond those 45 days. And there's nothing that prohibits a judge from extending it further, and some are willing to, some are resisting to. So it's within a judge's authority to extend it beyond that time. And unfortunately, I think that even in some of the more challenged areas that I mentioned, that these processing times are reducing, and MISTA looking at other ways to reduce these processing times, including farming out some of these cases to HARAs in other areas, and the self-attestation covering all eligibility factors. It's hoped that will accelerate the process in terms of the extent to which those applications have to be reviewed. It seems it's a little early to know, but the data is suggesting and showing that the processing times are moving along, not everywhere less than 45 days, but that's the direction that they're moving in. So, strongly hoping that, increasingly this is a smaller problem than it has been.
Okay, I don't see any other questions, so I'll give folks a minute to think just in case.
Allison,
Yeah.
if you look over, I typed answers to a number of others. And I did want to highlight one that two people made the point that in the Michigan's eviction process, the first step is a notice sent by the landlord to the tenant before they file a case. And so Desiree and Jeffrey pointed out, ask about, do you have data of, and we certainly, there are folks who would get that notice and then move before there's even a case filed. And that's an excellent point. But it's, as you can imagine, a difficult thing to observe. So in research, you either research data that exists, you collect your own data, but we do know from Matthew Desmond's ethnographic research in Milwaukee that he found there's a whole bunch of informal evictions where landlords using non-legal measures to pressure out different tenants without even using recourse to the courts. Now, I don't have any evidence of the prevalence of that in the state, but it certainly seems like that could occur as well. So we're definitely aware that we have a limited, view into what's going on. And maybe my final point here is issues like this is why we have a whole section about the importance of tenant education and empowerment and tenant organizing. And in multifamily buildings, it's valuable because then the tenants can inform each other of their rights and kind of collectively work with landlords around different issues. And there are models for tenant associations seeking collective representation or assistance from legal aid staff, et cetera. So, there's that may play a role as well.
Great, thanks for highlighting that.
Allison, I think I saw a question earlier on about what local government can do by way of response to some of these issues. And so, as even the U.S. Supreme Court said in its case invalidating the CDC order, that landlord-tenant law, including eviction law, is primarily a matter of state law. So there are some built-in limitations and sometimes issues of what are called preemption that state law overrides what local government can do. But still, especially cities, and some of you probably know this better than me, but cities in Michigan have what's called home rule. So that there is a fair amount of authority they have to address local issues, including housing issues. So I can offer some examples of what cities have done and have already, such as source of income protections, of establishing ordinances, especially ones that tenants can enforce, because in some places ordinances can only be enforced by the city attorney. And if you don't have a motivated and willing city attorney, that the law can be kind of useless. So, if they have provisions that tenants can enforce, it's sometimes referred to as what's called a private right of action, that can be really helpful. That there's other areas that I mentioned, fair chance ordinances, which enhance opportunities for persons re-entering society after some period of incarceration, perhaps. And also it might be a little trickier, but eviction ceiling programs and other examples are that some cities, so including the city of Detroit, has been moving on that, of requiring as a condition for a landlord filing an eviction case that if the city has a rental inspection program, including a requirement that a landlord has registered the property or has a certificate of compliance showing that their property has passed an inspection, if they don't have that status, they can't file an eviction case. So of really closing the courtroom to landlords who aren't keeping their property in decent shape. Other examples kind of moving on that continuum, I mentioned the benefits of good cause protections for tenants. And there's council member or a few council members in the city of Ann Arbor who are working to develop that citywide. There's a lot of landlord resistance to it, but it provides a really tremendous protection for tenants and does what accomplishes what's sometimes called security of tenure. So, that's a major objective here, is to create more stable housing for tenants, to make it a little harder to evict them and to make it easier for them to get more affordable housing that's in decent shape. So, I think that there are a number of measures that local government can consider. And, there's a risk that they might be sued as to whether this goes beyond their powers. But sometimes I think that conservative attitude can prevent cities from asserting themselves in ways that the law provides. So we'd be happy to talk more about some of those possibilities for local governments, but I think there are a lot of possibilities sort of along the range of issues we've been talking about.
Thanks for sharing that, Jim. I'm glad you chimed in on that issue. Can I ask you, there was a question about, so CERA is still, you can still apply, but a question that I have that perhaps others do is, how long is it going to be around? In terms of, we know there's money left, but is there a deadline or time limit to the program?
Yeah, so the deadline for ERA $1, so the money that's been appropriated, is September 30th of next year, or is it December 31 of next year? But then there's this second installment of money, the so-called ERA $2, which came through ARPA, which our state legislature hasn't appropriated, but needs to, because Michigan has to spend. So it's going to be also, that money will go out in a couple of installments, some of which the state treasury has gotten, but Michigan needs to spend some of that money by the end of March of next year in order to get more of it. But then that money would be available until at least the end of 2023. And if it hasn't been spent, until some point in 2025. So I think that money is going to be, I don't foresee that money being spent by all of that money. We're talking about still $800 million by the end of next year. I mean, it could be, but I think, and again, some speculation here, that money will be around at least that long, and maybe into 2023. And the hope is that there'll be more federal money coming through this infrastructure bill. Some of it would go for emergency rental assistance. And I think maybe the mix might be a little too high. We could debate this between rental assistance money and money for the development of new affordable housing, which could take the form of more voucher assistance dollars as well. So we'll see, but hope that some form of that legislation is enacted to provide both more emergency rental assistance dollars and more funding for more permanent assisted housing. And long-term, because that's been an issue in Michigan, that there have been ways for the recipients, especially in the low-income housing tax credit program, and this is maybe getting a little too policy detailed, but that the recipients of that money, or the investors in those programs, have found ways to get around some of the longer-term use restrictions. So with the tax credit program, there's a minimum 30-year use restriction or period when those restrictions apply, and some of these investors have found ways to get around those. So need some more protections to against that kind of abuse of the funding that some investors get through this program and some others.
Great, thanks for sharing that context. So there's time remaining here. Any other questions folks want to ask? I will say, Allison, this has been one of the most knowledgeable and engaged crowds. So, use our hopefully make use of our materials, and clearly folks online are really engaged in this issue deeply, and so they thanks for their contributions.
Yeah, way to go, group. So I don't have any questions that are coming up. So while we give folks a minute to just make sure they don't have anything else to ask, I would like to thank you both again for providing your time and expertise to our group. We had about 100 folks, so that's pretty amazing because I know everyone's really busy right now. So for you all to come and provide your expertise, and then the attendees to come and use their time to learn about this has been really great. A survey will come up at the end of the webinar. It will pop up automatically on your screen. It will also be in the after email. We would really love it to have your feedback. It helps me make sure that I'm planning webinars that are helpful and useful to you all. As you know, hopefully, as you know, Micah provides one free webinar a month, at least, sometimes more. This month, we actually have had 2 so far, and we're having 1 more. The next webinar we have is on the 17th. It's about the new gender data standards that are coming into HMIS and how to access those. So if you have not attended the first one and you're an HMIS user, we really encourage you to come. Also, if you enjoy these free webinars and you find them useful, Micah would love it if you or your agency could become a member. That is how we pay for these webinars and pay for the time putting them on. So the links are in the chat. If you do feel so moved to become a member, we would love to have you. Otherwise, you are invited to come back. Please fill out the survey. I don't see any more questions coming in. So I will just once again thank you both for coming, and reach out to me if you have questions, and I can forward them on to Jim or Rob if you did not get their information during the webinar. All right. Have a great day, everyone. Bye.
Thanks.
Bye-bye.
Bye, everyone.